Hello, everyone. Good afternoon. I'm Debbie Schrager, the director of the Supreme Court Institute. Before we begin, please note that a captioned version of this program will be available on Georgetown Law's YouTube channel later in the week. Audience members are invited to submit questions for our panel during the discussion using the Q&A feature at the bottom of your screen. Time permitting, the panel may address some of these questions. Now I'd like to welcome you to this conversation about West Virginia versus EPA, the consolidated cases that will be argued at the court on Monday, February 28th. The Supreme Court Institute is sponsoring this event. Each term, the Supreme Court Institute sponsors a variety of events related to the work of the court. Our signature program, of course, is our moot court program, which provides practice arguments for advocates with pending cases before the court, typically the week before argument. We offer moot courts as a public service at no charge and irrespective of the positions taken by counsel. This reflects our commitment to the quality of Supreme Court advocacy in all cases. In the most recently completed term, we provided moot courts to counsel in all but one case argued before the court, and we are looking forward to mooting counsel in the EPA cases. I'm now very happy to introduce the moderator for today's program. Sheila Foster is the Scott K. Ginsburg Professor of Urban Law and Policy at Georgetown University. She is a recognized authority on the role of cities and city leadership in promoting social and economic welfare, achieving environmental and climate justice, improving global governance, and addressing racial inequality. Professor Foster has served as the chair of the Advisory Committee for the Global Parliament of Mayors and is currently a member of the New York City Mayor's Panel on Climate Change. We are so very grateful to Professor Foster for moderating this event.
Thank you very much, Debbie, and thank you to the Supreme Court Institute and all the work that you do here at Georgetown. And welcome to everyone. I'm really excited about this panel discussion on the West Virginia versus EPA case. I'm going to start with a brief background on what the case is about and how it arrived at the Supreme Court. Then I will introduce our panelists and we'll begin the conversation. So as most of you know, if not all of you on the call, that EPA has the authority to regulate stationary sources, both existing and new sources that contribute significantly to air pollution. And coal and gas-fired power plants are subject to EPA's regulatory authority because they're stationary sources that emit greenhouse gases, which significantly contribute to air pollution. EPA's authority to regulate existing power plants comes from Section 7411D of the Clean Air Act. To regulate under that provision, EPA establishes emissions guidelines that identify, quote, the degree of emission limitation achievable through the application of the best system of emission reduction, end quote. The states must then submit, quote, standards of performance for any existing source, unquote, to achieve those targets. If the state submits a plan that EPA does not find satisfactory, EPA must then establish standards itself. In its 2015 Clean Power Plan regulation, EPA identified as the best system of emission reduction for power plants, one that incorporated three elements. First, improving the heat rate at coal-fired plants. Second, substituting generation from gas-fired plants for generation from coal-fired plants. And three, substituting generation from renewable energy sources such as solar and wind for generation from gas-fired and coal-fired plants. From these three components, EPA established an emission performance rate that states would have to ensure. EPA's target, however, could not be met solely through what are known as inside the fence line measures, such as technological improvements that reduce the level of emissions at a particular source or power plant. So how then could these targets be met? other than by coal-fired and gas-fired plants that reduce their production or emissions. One of the principal ways is through trading programs. Under such programs, an existing plant would acquire emissions credits by building or investing in renewable energy sources, and those credits would be treated as reducing the coal or gas plant's own emission rate. The Supreme Court stayed this Clean Power Plan rule, and after a change in administration, EPA repealed the rule and put in place the Affordable Clean Energy Rule. The court said that Section 7411 does not authorize the EPA to include generation shifting measures in its best system of emission reduction because Section 7411 limits it to inside the fence line measures, those that can be applied to and at the level of the individual source. The DC Circuit Court of Appeals subsequently invalidated the newer Affordable Clean Energy Rule, holding that the statute did not, in fact, unambiguously limit EPA to inside the fence line measures. After another change in administration, EPA sought and obtained a stay of the Court of Appeals mandate pending its promulgation of a new rule. The Supreme Court granted cert to decide whether EPA has the authority to include generating shifting as a method of emission reduction, or whether it's limited to inside the fence line measures. So that's where we are. To discuss the case and its implications for environmental jurisprudence, for administrative law jurisprudence, as well as for the EPA's ability to address climate change, we have a wonderful panel today. I will introduce each by alphabetical order, and then we'll begin our conversation. And after a bit of conversation, we'll be open to taking questions in the Q&A, as Debbie indicated. So first, I would like to introduce Kirti Datla of Earth Justice. Kirti is Director of Strategic Legal Advocacy at Earth Justice, where she leads the organization's efforts to anticipate and shape trends in court doctrine in the environmental arena. She was previously a member of the Supreme Court in appellate practice at Hogan Lovells and served in the Justice Department's Office of Legal Counsel, where she focused on federal environmental and land statutes. Kirti also clerked for Justice Sotomayor, for Judge Jeffrey Sutton on the Sixth Circuit, and for then U.S. District Judge Amol Thapar. Thank you, Kirti, for joining us today. Next, Don Elliott, who teaches environmental law at George Mason University's Antonin Scalia Law School, and previously taught environmental law at Yale Law School for 40 years, where he founded the law school's environmental law clinic. He's the author or co-author of over 80 articles and 8 books, including most recently, Advanced Introduction to U.S. Environmental Law. He has headed the environmental law departments at several law firms and served as EPA's assistant administrator and general counsel. Professor Elliott clerked for Chief Judge David Bazelon on the DC Circuit and for U.S. District Judge Gaurav Giselle. Next, Lisa Heinzerling is the Justice William J. Brennan Jr. Professor of Law at Georgetown University Law Center. Lisa has published leading case books on environmental and administrative law. She served as lead author of the winning briefs in Massachusetts versus EPA, in which the Supreme Court held that the Clean Air Act gives EPA the authority to regulate greenhouse gases. Professor Heinzerling has previously served as Senior Climate Policy Counsel to the Administrator of the EPA, as Associate Administrator of EPA's Office of Policy, and is member of President Obama's EPA transition team. Professor Heinzerling clerked for Justice William Brennan and for Judge Richard Posner on the Seventh Circuit. Thanks, Lisa, for joining us. Jeff Homestead, last but certainly not least, is a partner and co-chair of the Environment, Lands, and Resources Group at Bracewell LLP. He's represented clients challenging the Obama administration's Clean Power Plan in both the DC Circuit and the Supreme Court. He served as assistant administrator of the EPA for air and radiation under President George W. Bush, and was involved in the passage and early implementation of the 1990 amendments to the Clean Air Act. Homestead clerked for Judge Douglas Ginsburg on the DC Circuit. So welcome to everyone. Let me begin by asking about one strand of argument in this case. One of the major areas of disagreement is whether EPA's reliance on generation shifting in its approach to emissions reductions implicates what some have called the major questions doctrine. The court has invoked this doctrine twice in the past year, once to invalidate the administration's eviction moratorium, and once to invalidate the administration's vaccine or test mandate. In both cases, it described the doctrine this way. It says, we expect Congress to speak clearly when authorizing an agency to exercise powers of vast economic and political significance. So let me start with Professor Ellie and ask you, and then to invite the rest of the panelists to talk a little bit about this doctrine and whether and how it's applicable in this case. Over to you, Professor.
Well, I have two concerns about it. First of all, I believe that the major questions doctrine is an abuse of judicial power that is nearly as bad as the problem of overly broad delegations that it's trying to cure. I've pointed that out in a recent article in the American Spectator on January 31st. And I think it's particularly ironic that a court that claims we are all textualists now bases decisions on the unwritten, quote, intent that is largely in the judge's imagination or their own policy preferences. To me, this brings back the worst abuses of judicial power prior to the development of the Chevron doctrine. But if the court is going to imply that doctrine, despite my cogent objections to it, then I think that the amicus brief by Ricky Revesz in this case makes a really convincing case that many EPA decisions have as large or larger effects on the economy. In that regard, as DC Circuit Senior Judge Doug Ginsburg recently pointed out at a workshop at Scalia, there are now a spate of lower court decisions applying the major questions doctrine, because a great deal of what the administrative state does by rulemaking would violate the vague criteria that the Supreme Court has so far developed. So I think the Supreme Court is either going to have to narrow the major questions doctrine, or they really will deconstruct the administrative state, as was once promised by a Trump advisor, Steve Bannon.
Professor Heinzman.
Yeah, I agree that the major question doctrine has major problems, if you will. I think one of the problems with it that often goes unremarked is that the way that the court has been deploying it is skewed. It's skewed against regulation. So if you take two cases in the climate area, both of them, and compare the results in those cases, I think you can see this skew. In Massachusetts versus EPA, there were four dissenters led by Justice Scalia. And Justice Scalia said when EPA refused to hold that greenhouse gases were air pollutants within the meaning of the Clean Air Act, that judgment was due deference, right? Chevron deference, old-fashioned deference under the Supreme Court's doctrine in the Chevron case. Then a few years later, when EPA actually regulates under the Clean Air Act and introduces a rule that regulated greenhouse gases from stationary sources, Justice Scalia says that rule is not due deference. That answers a major question about regulation of greenhouse gases. And so we just look skeptically on that. And so if you ask yourself, what's the difference between those two cases? The difference is in Massachusetts versus EPA, EPA didn't want to do anything about climate change under the Clean Air Act, and that was fine with the conservatives. In the next case called Utility Air Regulatory Group, EPA did want to do something about climate change. Suddenly it's not okay. And so the major questions doctrine isn't just about answering major questions, it's about answering them in the wrong way. The other point is just, if you look at what the parties are arguing in this case, for the most part, they're not saying there's no authority under the Clean Air Act. They're just saying this is too much authority. But what that means is if EPA answers a question under this act and says, well, you know, we'll look at it again, and actually it's too much trouble, really hard, a lot of legal challenges. Let's just say that we will regulate efficiency at the source of pollution, right? If they do that, they're actually answering a major question. They're answering the major question about whether to regulate beyond the fence line under the Clean Air Act. It has the exact same economic implications, the exact same political implications. It's just a different answer. And I think so the court is smuggling in not only this incredibly subjective, and I would say not only weaponized, but aerosolized doctrine that is going to take over the lower courts, but it's done it in a really biased way.
Jeff, I suspect you might have a different view.
Yeah, I mean, I guess you won't be surprised to know that I don't entirely agree with either Don or Lisa. Lisa complains that it's skewed against regulation, and that presupposes somehow that agencies have should have enormous discretion as to whether to go one way or the other. But regulatory agencies only have authority that's delegated to them by Congress. And it seems to me to be sensible as a constitutional matter that, and again, I don't pretend that the doctrine is easy to apply and exactly where the bound should be, but it seems like we should all basically agree that if there are enormous decisions that they have vast political and economic significance, then Congress, if they want an agency to deal with it, they should speak clearly to that issue. And, in the famous words of the UARG decision that, when an agency purports to discover new vast authority in a long extant statute, that the judiciary is skeptical of that. So the idea that Congress under our constitutional system has some obligation to speak clearly on these issues, I think is sort of a sensible one. Now, we can debate, how it's applied in practice, but, and I don't understand why that can't be discerned through textualism. I don't understand why that's at all inconsistent with sort of the basic idea that you do it based on the text of the statute. But so to me, it seems a sensible approach. And figuring out the contours of it is going to be challenging, as is often the case when the court is drawing lines.
I know that both Professor Elliott and Hodgley may want to respond to that, but let me first get Kirti in and then come back around.
No, I'm happy to have both of them respond to keep that thread of the conversation.
Okay, Professor Elliott?
Thank you. Well, I think Jeff really goes to the heart of the matter. By the way, I agree with pretty much everything Lisa said, and that's not always the case, but in this case, I do. I studied under one of the key inventors of textualism, Robert Bork, when I was in law school. I generally fought with him in class, although we later became friends. But one of the points he made about textualism is that it requires Congress to pay greater attention to the words of the statute. And I think it's important that courts follow the wording of the statute. And if something is within the wording of the statute, whether or not it has previously been done by the agency, or whether or not the judges, as in the recent vaccine case, think that it isn't the intent of the statute, I think that's beside the point. If it's within the wording of the statute, then I think it's legitimate. And oftentimes, the one thing I might disagree a little bit with Sheila on is Section 111 of the Clean Air Act is one of many different provisions of the Clean Air Act. And the fact that EPA has not previously used this particular subsection of Section 111 in a way similar to this seems to me be entirely irrelevant from a textualist standpoint if it's within the wording of the literal wording of the statute. Now, having said that, although several of the key designers of the Clean Power Plan were former students of mine, and I think it makes a great deal of sense to allow trading from a policy standpoint, I've never really been able to get past the language of the statute that says in so many words, the states must be permitted to consider plant-specific factors, including their remaining useful life. That's an argument that's very well made in the North Dakota brief. And I think from a textualist standpoint, one might very well say that the a Clean Power Plan is outside of EPA's authority. Beyond that, I think this case is clearly moot. It's moot not because the DC Circuit stayed its mandate, but rather because EPA stated officially on January 12, 2021, that it did not intend to enforce the Clean Power Plan. So if the court reaches the merits, in my opinion, they're giving an advisory opinion. EPA has stated they're not going to enforce the Clean Power Plan, but instead they're going to go ahead and develop their own new and different rule. And from my standpoint, that's sufficient to resolve the case. I agree with the Solicitor General that the Supreme Court should probably vacate the DC Circuit opinion, which is now also an advisory opinion, and dismiss cert as improvidently granted. So that's where I stand.
Yeah, I want to come back to that, that issue in a minute, but let me give Professor Hines line.
I think it's great. It would be great. And I agree with you, Jeff, on this point, if Congress addressed major questions, but sometimes it doesn't. Sometimes it's ambiguous about them. Sometimes maybe it doesn't intend to be ambiguous, but it is. And the way I see the major questions doctrine and the non-delegation doctrine developing, and I hope I'm wrong about this, is that one day soon, statutory ambiguity on major questions will be unconstitutional. And that is absurd and deeply destructive of Congress's prerogatives. And if you think about it, it's backwards. It means that Congress will have the most trouble taking on big questions. It's exactly the opposite you hope for. The most trouble taking on big questions. Why? Because ambiguity is often inevitable. Sometimes it's accidental, and sometimes, yeah, it's intentional. Maybe everybody sees something in language that they think they can deal with and live with, and they're not sure how it's going to come out and unfold in the future, but they're fine with it. And so it strikes me as just a massive shift in power. And here's the other point about this. When you inflect a statutory question with constitutional overtones, you're saying that the court has the power to undo that congressional work. And it seems to me one of the reasons why we haven't heard from non-delegation in any major way in almost 100 years is the court's never been able to come up with partial, impartial, and durable standards for it. And I just don't think that asking whether a question is important in the minds of 5 or 6 justices is the way to have a predictable and impartial and durable standard for non-delegation. So I may agree with the policy point that you raised, Jeff. I don't agree with the constitutional overtones.
Any quick response to that, Jeff? Unmute yourself.
We can spend the rest of the time talking about major questions doctrine. I want to make sure we get to some of the other
Okay.
questions that we've talked about.
Okay, just wanted to be fair. Okay, so let me go to you, Kirti, with the next question.
Well, can I just make one point
Yes,
on the,
sure.
the major question doctrine, and I'll be quick about it, which is that I think, there's a couple of ways to think about how unusual this is in the context of what, a majority of justices on this court say they are doing when they do statutory interpretation. And one way you can see that is to look at the briefs in this case. And one thing that's striking about the petitioner's briefs in this case is that most of them start with an extended discussion of the major questions doctrine and why this is a major question. And the factors that they discuss are factors that you would never discuss if you were a committed textualist. Those include things like the relevance of unenacted legislative, bills, which is not how we interpret statutes, or the number of comments submitted, the number of public interest in an issue, and that's just not how one does textualism. And then the second part of their briefs, they'll get to the text, and the reason they do that is because, and this you can see in a fairly well-known opinion that Judge Kavanaugh wrote when he was on the DC Circuit, is because his version of the rule, which, we've only seen articulations of this new version on the shadow docket, and so we don't really know how everyone is thinking about this, but he seems to be a driver on the court. And his version of the rule is, I don't quite have a test for you. He says it's a know it when you see it test. So that's troubling right off the bat in terms of interpreting statutory text. And then he says it's a thumb on the scale against the agency's authority. And I don't know how big that thumb is and how much it weighs and anything like that. And, I think Justice Scalia, it's been pointed out in discussions about this case, criticized substantive canons like this because they are so indeterminate. When are they triggered and how do they work? And, I want to go back to something Don said at the very beginning, which is, the court needs to clarify the scope of the major questions doctrine. I don't think it should be applied here for lots of reasons. And I think clarifying it would be great. But part of me wonders if the lack of clarity is by design, because there are so many justices who have already signaled that they agree with the non-delegation doctrine, and that's what's driving them. They don't seem to be willing to say that in a decision, or can't get 5 votes to say that in a decision. And so they've created this alternate route to the same result. And as Don pointed out, lower court judges are taking up the call. And so it seems to me like this is a route for the sort of enactment of this view of how the doctrine should be. And the lack of clarity might be intentional on the part of the Supreme Court. And, we'll see in this case, but I don't know that some of the justices think it's a defect of their role.
Great. Okay, let's move on and talk a little bit about the substance of what the EPA is doing here and the backdrop for that, as well as the statutory authority. So one thing that has become very important to the court recently is whether there's precedent for the kind of agency or action that the agency is taking. For example, the court referred to the eviction moratorium as unprecedented, while it would refer to the vaccine mandate for healthcare workers as an example of the kind of power that the agency had long exercised. And the parties in this case debate whether there's precedent for the kind of action EPA has taken here. What do you think of that? Is there? And we have some very deep expertise on this panel in terms of EPA agency action. So let's start with you, Jeff.
Yeah, I was a little bit puzzled by the arguments made by some of the supporters of the, and again, I'm going to say the Clean Power Plan, because it really does kind of follow along those lines, that there is precedent for this type of generation shifting regulation, but it's always been done under parts of the statutes that specifically call for this kind of program. Under Section 110, under Title IV of the Clean Air Act, and the language that's in those specifically authorizes a cap and trade program, which has the effect of shifting generation, but that's not its primary design. The design is you have a particular target you're shooting at, and the cap and trade program lets you meet that target in the least expensive way. EPA has never done anything like this under Section 111, under either Section 111B or 111D. And the argument has been made that back when I was at the agency, we did a regulation under Section 111D called the Clean Air Mercury Rule, which did allow a cap and trade program for compliance with the standards. But the standards were not set based on what we could achieve by generation shifting. It again was based by looking at technologies that could be employed at a particular plant to reduce their emissions rate when they were operating, which is what Section 111 has always been about. And then there was a recognition that states could achieve that through cap and trades programs if they chose, but that wasn't the basis of the standard, and it wasn't compelled. So I think certainly we have a lot of experience in this country with cap and trade programs. They've been very effective. And by the way, I think the Clean Power Plan was, from a policy perspective, a sensible, sort of well thought out approach. I just don't think it had anything to do with what's permissible under Section 111D.
Okay, anyone want to jump in? Professor Heinzen.
I'm interested at how much smaller the question gets when you put it that way, so that you say, well, it's a major question. It allows us to regulate electricity, and never anything done like this. Got to strike that approach down. But then suddenly it becomes, no, we did do something like this before, but we set the standard differently. And so it was more stringent than this standard because it relied in part on that kind of mechanism. And that just strikes me as you're just haggling about a detail then. It just feels much less big in light of the discussion we just had. I'll say, I think this whole discussion that we're engaged in, because the court has been engaging in it, about historical precedent, just strikes me as another way in which the court is trying to limit the ability of agencies to respond to new problems and to respond them in creative ways. So not only is it going to look at whether it's attacking a problem under an old statute, but whether the agency has ever done anything like this before. And that just strikes me as retrograde. That just strikes me as really hamstringing agencies when they're engaged in their most important work, where they're trying to be creative and experimental, and the courts are saying, no, you have to do it the old way.
Jeff, it sounds like you want to respond.
No, I think there maybe at the heart of things here is Lisa thinks that these issues are so important that we should let agencies be creative in coming up with new solutions for dealing with these important problems. And I guess my view of the Constitution is that's really the role for Congress. And agencies do not exist to come up with what are effectively legislative solutions. Their purpose is to implement statutes that are adopted by Congress. And so I guess it's fair to say that maybe my starting point is no regulation unless Congress authorizes that. And Lisa seems to be sort of taking it from the other perspective, that if there's any plausible way that an agency can support something, no matter how distant it is from what Congress originally intended, or even in some cases the text of the act. So I do think there's sort of a fundamentally different starting point.
Professor Elliott, let's get you in here.
Thank you. A couple of points. I disagree a little bit with the way Curti characterized my argument. I didn't say clarify the major questions doctrine. I said narrow the major questions doctrine, which is a little bit different. I also agree with Lisa that you shouldn't really be applying the major questions doctrine, if it should exist at all, to a particular subsection of the statute and saying, has the agency ever done anything like this before under that statute, or that subsection of a 700-page typed statute. Most of the things that EPA does, or many of the things that EPA does, and that both Jeff and I and Lisa have all worked on, have major economic effects that are similar to what's involved here. Setting a new ozone standard, which has to be implemented by all of the states, is a perfect example, and yet nobody really challenges that. There are, however, I think better, and I guess I agree with Jeff that ideally, perhaps Congress should be making more of these decisions. But the practical fact is that given the pervasiveness of federal regulation these days, it's really impossible to imagine that Congress could provide all of the policy decisions that are needed to run a complex economy that is managed substantially by the federal government. So, bringing back the delegation doctrine, I think, is really a recipe for dismantling the administrative state and limiting federal government regulation. There are lots of standard reasons why one might question this application of trading or generation shifting that I think are obfuscated by the generality of the major questions doctrine. The first thing that bothers me about it is that we do have an agency that regulates what sources of electric power will be distributed over the grid. And that is called FERC, the Federal Energy Regulatory Commission. And Congress has repeatedly refused to give FERC the kind of authority to direct the generation shifting at the local level, feeling that that is a state responsibility. The other thing that I would find persuasive, and this is something that Jeff and I worked together when we were in the administration together in 1990 on the Clean Air Act, we actually had in the bill that was passed by the House, and I was one of the people that was behind it, we actually had a provision in the bill that purported to give EPA not only authority to do the acid rain trading program, but to do other trading programs for other pollutants. And that language was specifically taken out by Congress because the Senate didn't want to give that broad authority to EPA. And I think it would be much sounder for the court to use traditional approaches and say, you know, we have indications that Congress specifically decided not to give this kind of authority to do additional trading programs to the agency. I disagree with that. I, like Jeff, think that trading programs would be a good thing and we should do them more. And the Supreme Court has been willing to uphold them in connection with transboundary air pollution. It took 25 years, but eventually they did uphold a trading program for interstate air pollution. That has much broader implications than the Clean Power Plan. So I think that the kinds of tests that the Supreme Court is purporting to apply under the major questions doctrine really just don't work.
Okay, I want to pull in Kirti here, and then I have a question for Jeff. A follow-up.
Yeah, sure. So I just want to touch on a point that Jeff made, you know, and I guess potentially indicating he was disagreeing with Lisa, but I don't think that there is any disagreement there. Jeff says if Congress wants to give agency authority, it should pass a statute and do that. And I don't think anybody, including Lisa, disagrees with that. The disagreement is how do we decide whether Congress gave the agency that authority? And I think one thing that's so pernicious about this focus on the, you know, precedent and the very specific precedent for what an agency has done is that even if the text tells you that Congress authorized this agency action, it's almost like agency's authority gets sort of frozen in time. Again, I don't know how long is too long, so that's another bit of indeterminacy there. And that is another one-way, you know, ratchet, as Lisa pointed out with the major questions doctrine, which is that it freezes authority at a certain point of time. And I think it's particularly odd to apply that to a statute like the Clean Air Act, which you know, by design was intended to be technology forcing, to be adaptive as new pollutants became, you know, clear public health problems, as new sources became clear threats to the public health. You know, it's just so odd to say that you need to provide, you know, precedent for the exact type of regulation that you want to do in a statute that was designed to be more flexible and not the sort of command and control model. And, you know, if you're interested in this whole line of thinking, the brief, the amicus brief of the former power plant executives does, I think, a really compelling job in this case of laying out why some of these doctrines, including this, are just such an odd fit with this particular statute.
Great, and I just wanted to give Jeff an opportunity. A question popped up from the audience, I believe Professor Revesz. About as a follow-up, it says in the Clean Air Mercury Rule, which you referred to, EPA said that units for which it was not cost effective to install controls would use other approaches for compliance, including buying allowances, switching fuels, or making dispatch changes, i.e. generation shifting. How is that approach not analogous to the approach of the Clean Power Plan?
So there's no doubt that under Section 111D or 111B, generation shifting occurs because some plants believe it's not cost effective to do what EPA has determined is technologically feasible. And so under the Clean Air Mercury Rule, I think we made a determination that that technology was available for any plant. But we also said that states, if they so chose, could allow those plants to avoid what would otherwise be uneconomic choices by a trading program. But they were not set on that basis. If when people talk about the Clean Air Act and how it was designed to allow EPA to address new issues as they emerge, I think that's all right. But the Clean Air Act, it doesn't give EPA just broad authority to go and solve new problems. The Clean Air Act has dozens and dozens of different types of regulatory programs where EPA has prescribed what the standards are and how EPA can go about it. And it's certainly true when Section 111 was adopted, and especially 111B, that was designed to allow EPA to identify new pollutants that needed to be regulated. But it was clear that if you use the traditional tools of statutory construction to discern what Congress intended with Section 111D, it had to do with things that could be applied to a facility to reduce its emissions rate. There was no indication that somehow under 111D, the authority that the EPA asserted in the Clean Power Plan basically said, we EPA have the authority to tell which power plants need to shut down, how quickly they need to do it, when they need to be replaced by someone else. And that strikes me as problematic, whether you talk about it through non-delegation or through the major questions doctrine. That's an enormous power. And I think EPA exercised that power judiciously in the Clean Power Plan. And as someone who spent a lot of time at EPA, I actually have a fair amount of faith that they would probably exercise that power judiciously. There's a lot of very capable people who look at all of these issues. But the assertion of legal authority is breathtaking. If any stationary source of CO2 can be shut down because EPA thinks that's an effective way of reducing pollution, I can't imagine that that's something that Congress ever intended to give EPA. And I think we should all find that a little bit troubling, just because those of us on this call care deeply about climate change. The idea that a regulatory agency could assert that type of authority, I think is just problematic. And unless Congress clearly says you have the authority to make these decisions, to decide which plants can continue operating, which need to shut down, which types can be built in the future without some sort of clear statement by Congress.
And I want to focus us on the textual arguments in this case, actually, for under 7411D. A lot of the briefing is really, kind of parsing the language of that section and to determine whether EPA, in fact, has the authority to regulate outside the fence line. And I wonder if we can talk about what we think the best textual arguments in favor and against EPA's action here, just following up on the conversation that we were just having. So anyone else want to weigh in on the textual arguments? Kirti?
Sure. I mean, I think the one very compelling textual argument that is made in the briefing is that elsewhere in the Clean Air Act, including elsewhere in Section 111, Congress has used specific language when it wants to limit the types of emissions control solutions that the agency can consider or use or impose. In Section 111 itself, in a provision that isn't relevant in this case, it refers to a technological system of continuous emissions reduction, and then further defines that to be basically an at the source type of control. It uses retrofit technology elsewhere in the Clean Air Act. So when you contrast that with the words it chose in Section 111A and D about system, which is a pretty capacious word, I think that's a compelling, reason to read the word system as, just an ordinary person on the street would, which is that it's just a, set of, mechanisms that, achieve the end that's specified in the statute.
Can I just interrupt? Because I think that's a complete red herring. The question is not what's a system. The question is a system for doing what? And I think it's pretty clear from the statute that it's the best system for controlling emissions from a source that is operating. It's not what is the best system from some generic perspective. What's the best system for controlling pollution? No, it's what's the best system for controlling emissions from an individual source. And by the way, it's supposed to achieve continuous control. So the capacious definition of system, I think, really is a red herring.
Lisa?
I think it's interesting how the argument against EPA's authority here seems to always depend on adding words to the statute. So here it was adding words. What is the system about? It's a system for controlling emissions at the source. That's adding words to the statute. The statute doesn't say that, or adding at or to. It doesn't say that. And yet, on the other hand, I feel like there's no way I read this statute as anything but ambiguous. I'm reminded of Justice Stevens' comment apparently at conference when the justices were deciding the Chevron case years ago. And he said, when I'm this confused, I go with the agency, right? There is a way, it is a really, really difficult question, I think, about what this statute means. I think the best case for the agency is, and I'm sorry to say, Jeff, I think it's the word system. It's a very big word. It calls to mind systemic, which is exactly what the word is. On the other hand, and I've argued this in the past with respect to the Mercury rule, it does read like a kind of technology-based at the source kind of statute. That is the way a lot of the statute reads. And so I think it's just not surprising that you don't hear people saying that it's clearly authorizes EPA. It's all about what to do in the face of ambiguity. And that's where I think these tiebreakers come into play.
Don?
Well, I think EPA has not picked the clearest or best section of the Clean Air Act to regulate climate. I think there are plenty of other sections of the Clean Air Act, including national ambient air quality standards, which would achieve the results that EPA is trying to achieve. I argued they should have used national ambient air quality standards back in a speech, an article in 2008. So I think there are plenty of other sections that would have given them this authority. I respectfully disagree a little bit with my friend Lisa that the language of a best system is dispositive or requires adding words to the statute. The language actually, if we can look at it, is best system for an emission limitation. An emission limitation is also a defined term under that section of the statute, and it very, very clearly applies to reducing emissions at the plant. So this is section 111K. The term emission limitation means a requirement established by a state or administrator which limits the quantity, rate, or concentration of emissions of air pollutants on a continuous basis. So I must respectfully disagree, and I think the best textual interpretation is that this is something that EPA should do from a policy standpoint, but it should be doing it under a different section of the statute and not this one.
Can
I just point out that this discussion is really hard to do without showing the words from the statute and how they all fit together. And when you refer to one definition, but it includes another defined term. But I do think the briefs do a nice job of making the arguments on both sides.
Anything else on this? Statutory, okay. Let me ask Kirti the next question. A late addition to this case is the government's lead argument that the Clean Power Plan rule is effectively dead, and that petitioners are really asking for an advisory opinion on the scope of EPA's authority for future rulemaking. It is therefore asking the court to dismiss the case because there's no current case or controversy. What do you think about that argument?
Yeah, this is an argument that was made in the briefs in opposition. So, one reason that people who are concerned about the environmental and administrative law stakes of this case, I guess everyone involved is concerned, but concerned in the way that, that I'm concerned, one reason for that is because, leaving aside justiciability doctrines, the court's certiorari docket is discretionary. The court gets to decide what cases it takes. It was told at the petition stage, and it surely knew, because it was the one that had stayed the rule, that the Clean Power Plan never went into effect, that it was overtaken by events, just market-driven events, within, I think, 11 years. So well ahead of the schedule in the Clean Power Plan, all of the deadlines, the relevant deadlines in this case have been met. Emissions have been reduced to the degree that the Clean Power Plan, wanted them to be, even without the rule. And by virtue of an order of the DC Circuit, the Clean Power Plan is never coming back into effect even after the decision below. So the court knew all of that. And it's just a very odd, unusual, aggressive move for the court to take this case, because it knows that EPA is at this very moment writing a new rule that reflects the current reality. And, quite frankly, the court showed no hesitation in jumping in to review rules like this very quickly. So it knows it's going to have a shot very soon to review that rule, and yet it chose to review this case instead. So I think just even before we get to justiciability, there's something very unusual about this case that probably tells us something about this court. But I think as to justiciability, it's not clear to me that anyone in this case disagrees with the basic fact, which is, you can see it in the North Dakota brief. It says the Clean Power Plan was a legal nullity. You can read it in the language in the rest of the petitioner's briefs where they say the Clean Power Plan would have done X. There's nothing that it's doing at the moment or that it could do in the future. And so, yeah, it has the flavor of an advisory opinion. And I think if you want to get even deeper into the weeds of justiciability, the NGO's brief does a really good job of diving into the declarations that were filed, which is the only evidence supporting appellate standing in this case at the DC Circuit, and finding that nobody challenging the rule, nobody challenging the decision below at this point has a stake in seeing the affordable clean energy rules spring back into existence, which is really what a decision reversing the DC Circuit would do in this case. And so all of that to me means that there's something very strange happening in this case, and it's good that the court has an out in terms of the justiciability arguments that are being made.
So I was going to ask about the out, given the, some have referred to the court as a 3-3 court, a 3-3-3 court. And I wonder if this does give the court an out versus instead of a fractured opinion. Anyone else on this, on the idea that it's a mooka? Yep, Lisa.
I don't think they want an out. I think they deeply want to answer this question. I think they've been waiting since February 2016 when they stayed the Clean Power Plan to answer this question. They remind me, Justice Kavanaugh, interestingly, we may not remember this, but the one coal company, Murray Energy, challenged the proposed rule, which was a very, very sort of interesting administrative law move to challenge a proposed rule, but they challenged it. Then Judge Kavanaugh writes an opinion and says, petitioners are champing at the bit to challenge EPA's anticipated rule restricting carbon dioxide emissions from existing power plants. But EPA has not yet issued a final rule. It's only issued a proposed rule. Petitioners nonetheless ask the court to jump into the fray now, but we can't. It's a proposed rule. We don't even have a proposed rule here. So it's even one step removed from what Judge Kavanaugh had no problem saying was not ready for judicial review, already arguably in this same case, if you view the whole timeline of this case. And so it strikes me, whatever ground you use, rightness, mootness, standing, right, they're all so similar to each other that it's hard to say what, it seems like this isn't justiciable, but they took it. They took it in the face, as Kirti says, of an environmental group raising these points, adding it as a separate question presented. They haven't asked for any affidavits on injury. They haven't asked for anything that would show the kind of evidence that environmentalists, if they were up in front of the court with something like that, would have had to show. So it's very odd. They relisted it like 3 or 4 times before they decided to take it. So I think they don't want an out. I think they want to decide this case on the merits.
Okay, Professor Allen?
I find myself in substantial agreement with Lisa and also Curdy. I think one of the reasons they granted cert was the DC Circuit opinion was, in my view, incredibly arrogant in that it did not even bother to cite the Supreme Court stay. And the stay of a case that is pending in the lower courts is really unprecedented, an administrative law case. And so I think it was an extraordinary action. And I believe that the DC Circuit, as a former DC Circuit clerk, I think if the DC Circuit essentially thumbs its nose at the Supreme Court and doesn't even address the arguments that led the Supreme Court to issue a stay, I think that's one reason that the court took it. I do agree with Lisa that they're chomping at the bit to decide it. I suspect that if it is dismissed on justiciability grounds, that there'll probably be some dissents which attempt to address the merits. Of course, as we all know, the decision by the court to grant cert in the face of these arguments being raised is not stare decisis. It's not binding on the court in any sense. I think whether the court wants to decide the case or not, I think the Solicitor General and the government and environmental groups are doing a very wise thing in trying to persuade the court not to address the issue. Doctrines like justiciability exist precisely for the purpose of constraining the court from doing what it may want to do when it's inappropriate. And I can remember back when I was in the government that sometimes the Solicitor General's office did not want to raise the Chevron doctrine in defense of an interpretation because they were afraid that they might lose it. And my view is that the Solicitor General's offered to the court that it should vacate the DC Circuit opinion, so it's no longer a precedent, but not decide the case on the merits is very sound as a matter of law, and also a very sound strategy for the government to be pursuing.
Can I quickly address this?
Sure.
Because I think this is one issue on which I largely agree with everyone else. I was certainly surprised that they took the case. I still think that there is some chance that it would be dismissed on those grounds, and I do think the SG's brief, which specifically reminds the court that if it's unhappy with the DC Circuit's opinion, which I agree was sort of breathtakingly broad, that can be vacated. So EPA really is writing on a blank slate, and I kind of wonder if that DC Circuit opinion had been a little narrower, if it would have, if we'd be in this position right now. One other thing that I, at least maybe as a former EPA official, find sort of ironic about all this is, I think the administration appointees at EPA were quite confident that if they tried to do something like the Clean Power Plan, it would not pass muster in the Supreme Court. I don't think they had any interest in sort of trying to revive that approach. So I think that if they were writing on a blank slate, I have some ideas about what they might have done that would have been substantially more aggressive than the ACE rule, but would not have relied on the kind of generation shifting. And at this point, we don't know what they would have done on their own, because I think they're wisely going to wait and see how this case comes out. But I count myself among those who were puzzled. And it'll be really interesting if they do take the case to see how they deal with the standing, ripeness, justiciability issues, because just like in Mass v. EPA, we sort of got some new case law on standing with regard to state standing. We may, I wonder, are we going to have some sort of capable and of repetition and evading review, kind of theory here? But it will be, as a matter of administration law, it'll be very interesting.
So it's good to have agreement on the panel. And just one point on this from the audience. Someone said, just noting that the standing ripeness, mootness arguments were not fully briefed in the cert ops. The argument then was more prudential. Don't get involved while we're writing a new rule. So it's possible the court wasn't fully aware of all the jurisdictional shortcomings at that stage, but they'll have to be addressed now. What do you think about that? Yeah.
I think that's right. As a practical matter, many of the justices do not read cert petitions and briefs in opposition. They're read by clerks, sometimes by a single clerk who advises multiple justices. And the court often dismisses cases saying cert was improvidently granted when they get deeper into the case. And I think that's the right thing to do here. Whether or not the court is chomping at the bit to address these issues, I think they clearly would be an advisory opinion, and it would be an abuse of power by the court to address the merits. But I do think that they should vacate the lower court opinion. So as Jeff says, they would be writing on a clean slate. And I agree with him. This is not where the current administration at EPA is planning to go. They have written some letters in response to citizens' petitions to do one of the things that I've advocated in an article, which is charge a user fee on releases of greenhouse gases. In response to that, the AIR program wrote a long letter signed by Joe Goffman, the principal deputy administrator for the AIR program, a longtime EPA veteran. And in that letter, Joe outlined all of the things that they're planning to do on climate. And nowhere in it is anything suggesting that something like the Clean Power Plan is being contemplated by the current administration. So I think it would really be a purely advisory opinion.
Just going to respond to the question. It was raised. It was raised in the environmentalists' brief in opposition to cert. The U.S. government said that it would be to render an advisory opinion. They didn't dwell at length on it, but it was quite clear what they were talking about. And in addition, the Supreme Court is always saying that it has an obligation to make sure that it has jurisdiction, even when it's not raised. And so it strikes me that they would be sort of violating that principle that they've stated over and over again in environmental cases against environmental standing if they didn't look at this seriously. I also just want to prepare everyone for the introduction potentially of a new verb to our language, if you don't know it already. When the Supreme Court says, you know what, this case became moot on appeal, but because we can't review it then, we will vacate the lower court opinion because there wasn't a chance for review. That's called Munsingwaring a case. They Munsingware the case after the name of the case. So it just struck me from the very beginning. I thought the answer to this case is Munsingware. Just Munsingware it, right? That's your new verb for today.
Can I just
Yes, go for it.
Just a quick question. What do we make of the grant of cert in the WOTUS case? I mean, isn't it very similar? I'm not a Clean Water Act expert, but it does seem to be yet another example that the court is looking to, and from a practical perspective, you'd say that issue's been up and down so many times, maybe we should just resolve it, but that's not normally the way the Supreme Court decides whether a case is reviewable.
That's such an excellent question, Don.
Well, I do think the WOTUS case, the Waters of the United States case, is really quite different because in repealing the Trump administration's repeal. The Biden administration specifically said that the pre-existing rule would go back into effect. So I don't see those issues as being moot or non-justiciable in the way that I do here. I don't think that the DC Circuit simply withholding the mandate and sending the issue back to the agency, I don't think that necessarily creates non-justiciability, because I think that would be subject to a great deal of manipulation by the lower courts. But I think that the extraordinary action of the Biden administration coming out and stating specifically that they have no intention of following or enforcing the Clean Power Plan, which is very different than in the Lotus case where they said the opposite. I think that is what makes this case non-justiciable.
Kirti?
Yeah, I think I'll just add that I think I agree that there are differences between this case and the Sackett's case, and this case might be more odd, more aggressive. But in the Sackett's case, just for anybody who doesn't know, it's a case about, whether a parcel of land is covered by the Clean Water Act. The homeowners there kind of filled up their land to build a house. EPA said, you needed a permit for that, and you need a permit for anything you do going forward. As the case comes to the court, EPA said, we're not going to enforce the statute against you for anything you've done in the past. If anything happens in the future, you're probably going to be judged against this new rule that we're working on, again, at the moment that the Supreme Court was deciding whether to grant review. And so I do think it's another example of, what's the rush here? In this case, in the Sackett's case, it's not clear what the stakes are for the Sackett's really as a practical matter. And, this is another hugely seminal environmental statute that the court is acting aggressively to opine on. And, it may be less aggressive than this case, but it's a huge statute and they're deciding the scope of that statute. So I think it's troubling, if not maybe equally troubling.
A quick detour, and then I want to come back to what happens post the opinion. But one of the interesting features of this case is that we have states on both sides. West Virginia is lead petitioner for a large group of states. New York is the lead respondent for another group. One group is arguing that the EPA is intruding on state authority. The other group is arguing that the EPA is protecting state authority. Just I want the panel to comment on which side you think is right and what are the implications for winning one side or the other. And that's the state and local government scholar in me. Really curious about this. Lisa, are you?
Well, I think I think that it is ironic that the states are complaining, given that it was the ACE rule that really forbade states from taking any approach other than the one that the EPA specified. So they're the ones who said, you can't go outside the fence line even if you want to. And that strikes me as a more just explicit, open intrusion on state authority than the Clean Power Plan itself. I do worry that, the Supreme Court is clearly swinging for the fences these days. And one of the things that I worry about is whether they have a problem with cooperative federalism and whether they see it as really the cooperative is kind of in scare quotes for them, and they don't like it. And so I do worry about them taking aim at that, not because I like it so much. I'm not a big fan of cooperative federalism, but because it's such a basic part of the environmental protection infrastructure.
Wonderful. Anyone else? Yeah. Kirti and Don.
Yeah.
Oh, I'm sorry. Who should go first?
Okay, I'll be quick.
So-
I was just gonna say,
Okay.
I think this is another area where there's just sort of an odd baseline problem. So when you read some of the petitioners' briefs, it's, power generally is part of the state police power, state regulatory power, and it's sort of like, most of environmental law is, something the states could regulate, but for the interstate commerce nature of it all, and so like, what are we doing here? There is a statute, Congress did legislate, it did take away some state power, and so that can't be the baseline. And then, this is similar to what Lisa said about what are we looking at for precedent. It's the state ability to set, make sure their generation sources are reliable. It's the state ability to, some briefs say, without, at least to my mind, much elaboration, that, states would have had to take action. And so there's a weird commandeering angle to all of this. And it's especially in the area of environmental law, it's always going to be federal, the federal government coming in, Congress passing a statute, often after leaving it to the states and having that fail, and then passing a new statute that has more authority given to the federal government. And so I find these arguments hard to grapple with, just because I don't quite know, it doesn't seem like everybody's starting from the same baseline and asking the same question.
And I will just note that it's really no longer strange to have states on both sides of these cases. Every big case that I can think of has had states lining up on both sides. And I kind of agree that I think the states' rights issues are sort of secondary here and a little wrestling. And I do think that the ACE rule was illegal in taking away states' authority, but anyway, that's an issue that it would be unlikely we would get a decision on in this case.
So unless you have something, Don?
Yeah, if it's my turn. I agree with the point Jeff made earlier. It's hard to argue about the statutory basis of the case without really being able to show the text to everyone. But Section 111D of the Clean Air Act, which is the section that EPA purports to be using here, begins, the administrator shall prescribe regulations which shall establish a procedure similar to that provided by Section 7410, which is the SIP provisions, under which a state shall submit to the administrator a plan which establishes standards of performance for any existing source. So I think that that it was decided in the Union Electric case in 1974 by the Supreme Court that one of the fundamental principles of cooperative federalism under Section 7410 or 110 of the Clean Air Act, which is specifically cited here, gave the state discretion how to achieve the overall goals. And here, as a practical matter, the only way that the overall goals can be achieved is by generation shifting to gas and renewable sources. So I think there is a strong argument that you ask about whether, which side I thought states had the better argument. I do think that that Section 111D1 primarily relies on state authority to regulate existing sources. And I know as a factual matter that's how EPA historically interpreted this section. And that was how it was explained to me by the General Counsel's office when I was General Counsel. And I also know that under the Obama administration, they specifically went back to the General Counsel's office and said, do you think that the language about prescribing regulations to establish a procedure by which the state shall submit a plan was broad enough to allow EPA to dictate as a practical matter generation shifting? And the General Counsel's office said, yeah, we think we can defend that interpretation. But on balance, if the Clean Power Plan is not consistent with the statute, and of course that's the issue on the merits, I do think there's a pretty good argument that it is in fact depriving states of discretion and authority that they're given by the statute.
Okay, wonderful. We don't have much time left, so I want to turn to the aftermath of the case. Just reading between the lines, there seems to be a significant chance that EPA loses the case. And if that happens, I know a number of audience members would want to know what are the best options the agency has going forward in regulating power plants. And more particularly, a couple of audience questions are asking about other parts of the statute, as we all have already discussed, that there may be other options in the statute section or the NACs rather. And one question asks, and let me start with you, Lisa, on this question. In Mass versus EPA, the majority expressly rejected EPA's argument that regulation of greenhouse gases as air pollutants required express congressional intent due to the significant economic and political implications of regulation. How would a holding that EPA cannot regulate under this part of the statute be consistent with that part of Mass versus EPA? And if EPA has authority to regulate greenhouse gases as air pollutants, so first of all, is that a way forward? And second of all, why is that authority absent when the regulatory application is so much more limited? So just the way forward and other possible statutory authority and regulatory avenues.
Yeah, I think that the way forward, just legally speaking, if EPA loses under Section 111, there are other provisions they could use. They could think about a national ambient air quality standard for greenhouse gases, for example. There are other provisions as well that they could think about using. I think what they would have to do is show that, and they already have to do this, but show that on a provision by provision basis, it makes sense under that provision to use it for this purpose. I think that that's what we're left with in Massachusetts versus EPA. I think the authority to regulate automobiles and trucks is solid, but I think we were left with that provision by provision search after, even after the utility air case.
I'd like to address that issue if I could.
Yes, go ahead, Jeff.
Jeff, okay.
So I don't think there's any chance that the court will say EPA does not have authority to regulate under Section 111D. So I don't think they'll lose the authority. The question is, how broad is that authority? And I do think the agency is looking at things that would not be based on generation shifting. And I think what they would be doing is setting standards or establishing guidelines, but allowing then states to choose more flexible ways of meeting this sort of source by source approach, very similar to what happened in the Clean Air Mercury context. So I do think they'll continue to have authority. I think the big issue that EPA faces is, I think that their authority to regulate mobile sources, cars and trucks and other mobile sources, is pretty clear. And it's sort of a well-worn path. They set standards for new mobile sources, and that's easy enough. I think it's also easy enough when it comes to methane emissions. The way in which they regulate is the same that they've been regulating for a long time. And it's the same that they do for VOCs and other things. I will notice with some amusement that they have that same authority to regulate farm emissions, but I think notwithstanding that authority, EPA is unlikely ever to use the Clean Air Act to go after those. I think the big challenge they have is they just don't really have good tools to regulate CO2 emissions from stationary sources. It just, the program doesn't provide the agency with the tools that can be effectively used. And I think that's one reason why, as much as people may distrust or be skeptical that Congress will ever do anything here, I think that's an area that we're going to need some further congressional action. And to some extent, we're seeing that, right? I mean, we're talking about massive tax subsidies and credits and grants. And at least for the power sector, that may be more effective than sort of regulatory authority, but that doesn't solve the problem of all the other industrial sources. And you don't have the same easy kind of generation shifting there either. So, even if EPA could come up with an effective regulation like the Clean Power Plan, I don't know what that does to all the other stationary sources, which I think are really much more difficult for EPA. And I will just say that I'm skeptical that EPA can set an axe for CO2, but that should be maybe a whole separate discussion.
Right, exactly. Don, and then Kirti.
Well, I think that I agree with a lot of what Jeff has said, that it's difficult to regulate CO2 under the Clean Air Act. I think that the court in Mass versus EPA did not fully appreciate how difficult it would be to regulate CO2 under the existing authority of the Clean Air Act. However, from a textual basis, I think it's important to note that the word climate does actually occur in the definition of welfare effects for secondary standards for national ambient air quality standards. So there's a specific requirement in the statute that in setting secondary standards, EPA has to consider the effect on climate as well as weather. And they both are included in the text of the statute. Now, one of the reasons that it seems odd to regulate CO2 under the National Ambient Air Quality Standards is all of the National Ambient Air Quality Standards to date have been concentration standards. So much pollution per unit of air. The statute does not require that. That is simply the way we've regulated in the past. But it would be quite possible for the agency to set a rollback standard, which is the way that most standards for CO2 have been set, based on a percentage reduction from the emissions that were taking place at a certain period in time. So I do think that, and one of the advantages of regulating under Section 110, as Jeff and Lisa certainly know, but Jeff and I were involved in this, Section 110A2 was specifically amended by the 1990 amendments to allow states to use trading systems in meeting national ambient air quality standards. So if you're looking for a trading system, which is the most logical way to regulate CO2, I think setting a national ambient air quality standard based on a percentage reduction from 1990 levels, which is the way that we've measured progress on climate change since the Rio Treaty, would be a very logical way to go. But I've been a voice crying in the wilderness on this for a long time.
Okay, Kirti, and then I want to give everyone a last word.
Yeah, I, unlike the court, am not willing to get out ahead of EPA. And I think if the other panelists are any indication, there are really, really smart brains that work at EPA and are attuned to just how pressing of a problem we're facing. And I'm hopeful that even if there is a decision that I personally don't like, that there are ways to address CO2 emissions from the power sector, which, just so people know the stakes, I think sometimes these decisions in this discussion can seem a little bit technical or abstracted. You know, that's, as of last year, it's about a third of the emissions are from the power sector, and coal in particular is just over half of that. And, you know, I mean to imply at all that the only options on the table are the ACE rule versus the Clean Power Plan, but the goal for the Clean Power Plan was a 30% reduction over 15 years. And the ACE rule, which was premised on a very narrow reading of authority under this section, was predicted to have a 1% reduction, if even that. So I think that's helpful to keep in mind as we're thinking about this like hyper-technical statutory language and big questions of administrative and constitutional law, that there are real climate stakes here in this case.
Okay, great. We're out of time, but any last words, short last words that you want to get in? Okay, I'll invite Debbie back to do a proper closing.
Hello, everyone. Again, I cannot begin to express our gratitude, the Supreme Court Institute, the audience. I'll speak on behalf of the audience for this extraordinary conversation. The expertise here is astounding, and I can only imagine that this could have gone on much longer and there was much more room to cover. But I want to thank you all very much. I want to thank everyone who's attended and this extraordinary panel. And I look forward to hosting future events with our extraordinary faculty and friends of Georgetown. Thank you again.